Welcome back to the House Judiciary Committee this Wednesday afternoon, May 7th. And we'll take a little more testimony on H98 that we were hearing from witnesses this morning. We couldn't quite get to Judge Zone, but we have him lined up for S12 after this. So we'll start, though, with
double header.
Yeah, double header. There you go.
Good afternoon, Tom Zone, Chief Superior Judge. On H98, the issue that you were addressing this morning is the standby guardianship language. We've reviewed it. The critical part for the court was that that the bill would be implemented in a way that did not have the filings ahead of time. In other words, once the adverse immigration action has been taken, then they would be able to file. At this time, we have no prediction other than the information we've received from Ms. Prine, for instance, about how many families or how many children. We don't know if we're going to have a significant number of these cases or none. So as far as resources and the impacts on the court, we don't know what's going on. I would note that right now, we do have minor guardianship, so people can come to court and file their minor guardianship. And one of the issues that arose was, can you have you heard the term this morning, springing guardianship, I think has been referenced a few times. Some states have those specific. Vermont statute doesn't talk about that in particular. And so I think one of the reasons that that Legal Aid and others were looking at this bill was because it provides some clarity. Because right now, someone could try it and say, well, we think the law allows it. And maybe some judges would say yes, some judges would say no. And that doesn't give the type of stability that's helpful throughout the state until the Supreme Court decides one way or the other.
Yeah.
Also, parents could come in now and enter into consensual guardianships. Obviously, I think the concern that's been raised there has to do with it's a public proceeding, and so there may be if someone is here and there are immigration matters, they may not want to get their address and name out there. And so I understand those concerns. And so when we look at this bill, it's a policy decision by the legislature. As I think Ms. Prime was talking today, if the parents are taken and the child is a U.S. citizen, we're going to see that unless there's a guardianship or unless something happens where they've got close friends and it never reaches anything. But even at that point, whoever the child's with is going to need some type of legal authority over them to register them for school or get medical attention, whatever it may be. And so I think, as Ms. Prine said, we would agree that if let's say a child's at school, parents are taken that afternoon, if they don't have one of these provisions, if they don't have a guardianship, what's going to happen is DCF's going to get called. That case will then go to our family court into the juvenile division. As you know, then that starts the whole CHINS process there. If the parents are taken from the country and they're living somewhere else, questionable how you can reunite them. The reunification was one of the goals. And so my understanding is in some jurisdictions, they work with consulates to try to have home studies done in foreign countries. But those are questions I think would be better for DCF. But I do know that there would be difficulty with reunification. So the understanding that we have as far as the guardianship is that it doesn't go to there. It goes to someone who may have agreed to take care of the child. And we don't get into the situation of, well, we need a home study in Ecuador or wherever it may be. Because if the guardian has the ability and the parents have the money, the guardian can make arrangements to have the child sent back and you can terminate the guardianship. And so it's a policy decision for the legislature. Enacting the bill it brings with it some clarity in an area where, again, some judges may think that there is the authority to do it now. Some may think there's not. It's interesting when you look at, okay, if it comes into the CHINS, that's going to be in our Superior Court with the family division of the Superior Court. If it comes in as a guardianship, it's going to be in the probate division. And then we may have issues where if you have a lot in one county, it could backlog that probate division as far as moving ahead. So we have to try to see about getting additional resources there. The probate division is a little different, though. Elected counties, things like that. So if the bill does pass and we need extra help somewhere, we're going to take the steps to make sure that the policy the legislature wants effectuated is effectuated. And so we'll do what we can to make sure that we get the resources there.
So the guardianship study in the miscellaneous bill kind of gets to that issue somewhat, does it not?
I think it touches on it, yeah.
Questions for Judge Zonin?
You want me that quick?
Oh, that's right. I forgot Tom that quick. Tom Oliver, out of sight, out of mind. I'll lean back so I can see him.
I would just ask, if it did get busy for you, what resources or stuff do you think would be the most taxed and maybe not prepared for?
I think just time. For instance, Chittenden County, we have a probate judge who, the way the probate structure is, every probate judge is elected for the county. And so my view has been, you are the probate judge. And however long it takes you to get the work done in your county, you're the judge, you need to do it ethically, responsibly, and you need to take that time. The way it was set up years ago is that the Chittenden County probate judge is paid at what they call the full rate. So they view that as, quote, the full time. And then other counties have judges who are paid at lesser rates. And for instance, it may be 2/5. And so there may be perceptions amongst some that, well, I only get paid for 2/5, so therefore I'm only working 2 days a week. But so when we have, if it was Chittenden County, for instance, the judge there has a busy docket and he might have difficulty. Right now, if they have a guardianship for a minor come in as an emergency, it's generally heard promptly. I know that we have you heard this morning about the 72 hours, the 3 days, if the emergency guardianship is granted. There's a process in place for seeing if DCF is involved and protocols in place to address that, and the court tries to get it in. If next Wednesday, if this bill were in effect and next Wednesday there were 20 guardianships that came in, that would be difficult for that judge. And so what we'd have to do is try to get additional judicial resources to address that.
Is that court, I know all courts are to some degree, and some are more efficient than others about like interpretive services. Would that be difficult? Is there enough? Do you need any of that?
We have a division within the judiciary that works on interpreter services. And while we utilize interpreter services all throughout the state, I think it's safe to say that Chittenden in that building, in the Costello building, as well as in the county building, I think up there we have a lot of institutional knowledge with the staff on how to maximize our resources for interpreters of various languages. And I actually have some ideas now, and I haven't talked to some of the judges about them. So I prefer not to do it on public for the shutdown kid. But I do have some ideas on how we would take care of it. And in fact, I have the authority to appoint a superior judge to also serve as a probate judge. And so if we have the resources of a superior judge, we can even have them do some probate work in cases like this to assist.
Ian.
Thank you, Judge. I had one question that came up this morning on page 14.
I don't have the same pagination you did. Which section?
Oh, yeah, you can also just use that copy. The court needs to make a finding that the custodial parent made consented knowingly and voluntarily, and the emergency sort of route that this could take would allow for just the signed consent. Would that be an issue for the court to make a determination?
We currently operate in some areas like that anyway. For instance, in the criminal division, we can, under Rule 43 of the Rules of Criminal Procedure, we can do a waiver of appearance and the entry of a plea. And the court has to find that a plea of guilty is knowingly, voluntarily, and intelligently made. And we can make that finding from the papers through the representations.
Okay, great.
Any other questions for Judge Zonin? Before we transition to S12. Not seeing any? All right, so we'll move to S12 and just to make sure we're all looking at the same draft. Which is, I believe it's draft 1.2, right?
39 on 5.2. I would On page 15 of that draft, lines 16 through 18,
Page 15, you said?
15, yes. It includes language that says that the court shall issue the petitioner an order of sealing and provide notice of the order to all entities provided by the petitioner. We don't currently have anything now that allows the petitioner to come in and tell us who to send something to. And so my concern with that is what happens if they come in and give us people whose address it comes back, the returned mail? What is the court's obligation to track things down? What happens if they it doesn't say they have to give us the entity, the address. So if they say, okay, here's the name, is the court now obligated to go out and find who to send these to? And I guess my final question would be, doesn't the current statutory language about where we send things to address what we need to? I don't know. I don't know where this came from. So what the reason was.
It came from OPR licensing entities that they want to know if, they may have gotten documents and nobody's telling them that certain documents have been sealed. So they really have no way. And this was an attempt to figure out a way that a petitioner would have the obligation to say that they applied for a license and the record was used at that location. So, so I mean, if we put kind of standard language as far, well, if we either the thing is that the individual probably doesn't know what the address is for the Secretary of State's office and such. I mean, it's generally we're thinking it's going to be public entities.
And I know that the concern for trial court operations when I discussed this language with them was that and that's a great example. That yes, that's an easy one. Secretary of State court should be able to take care of that. But this goes broader than that. And so if this was some organization in Wichita,
Right.
Public agency there, are we supposed, is the judiciary staff now going to have to start tracking it down? So I think that's the concern, is that it's going to create work. And the thought is that if they have we're going to be providing a copy to the petitioner. If they know, instead of giving us the information, they can send a copy of this to that entity themselves. In other words, put the obligation on them to send a copy of whatever it is to entities that we're not aware of.
So here was also the thought on this is, and we didn't write language in here, but just to back up, part of the concern was not to have the court send every single sealing order to the Secretary of State's office, or the Office of Professional Regulation, because they'll be overwhelmed and most of the time they don't have those records. So, but we're talking about having in whatever form would have a checkoff box of those entities that we know in the state that would have or could have somebody's records. And the person would check off that, that OPR or.
So if it said, and provide notice of the order to Vermont state entities identified by petitioner, that would be what you're saying. They check off which ones may have it, right? That's different. That if it's Vermont state entities, we can do that. One makes sense because we have an obligation to send it to other places that we know may have records. Right. And so if they identify that the Secretary of State has or OPR has records, I don't see an issue with that one. But as it's currently worded, all entities doesn't differentiate between state and public or state and private. It doesn't differentiate local or across the country.
Okay.
From Vermont State, just adding that piece.
I mean, I don't know that we can't tell federal agencies to seal. Can we? No, I don't believe we.
I don't think they listen.
Yeah. because this also, it relates to the language on page 24. That's probably where we say any other state entity identified by the petitioner.
I would say Vermont State.
Vermont State.
Yeah. And that's on line 7 on page 24. So yes, that's where I got the identified language. I think if you use that language, I think it accomplishes what your concern is, and it doesn't overwhelm the courts because we should be able to handle that.
So we had discussed adding, or persons, but I think that makes it even more complicated. I don't know that the court should be obligated to figure out the individuals that the petitioner has identified. Yeah, I sent my criminal record to my mom.
What if the petitioner says, oh, by the way, I remember Vermont Digger did an article on my case, and I'm sure they have records, and they're an entity, so you have to send it to them, and they have to seal it. It could be, I think if you make it very clear what you're working on here.
State entities, yeah. Okay, all right.
On page 25, where you talk about we'll call them the exceptions to sealing, these are policy. And they're clear and understandable.
Well, that's positive. I don't think they were clear and understandable before.
I think it makes sense. Obviously, some people can always raise concerns and say that it's murky and they don't understand it, but I think that from our purposes, it gives us what to work with, and if concerns arise, we can address them.
Sarah, can I ask a question?
Oh, yeah, Karen.
I appreciate that you said that they're clear. One of the notes that I had down, though, is that maybe it's not clear of when because we go back and forth between access records and used records. Do you feel like that is clear?
That has been an issue before you started on this bill.
Okay.
Because the question is, what happens when you get them? And that's a great point. I think that there is an argument to be made, and it has been made. I've seen it that, well, you can access it, which means you sit here, look at it, but you can't use it for anything and use. And so if you can clarify that, that certainly would not do any harm. But that's been an issue that has been around juvenile records, criminal records in the past.
There's not a good solution, what you're saying.
Interestingly enough, I don't think it's really bubbled up in such a way that we've had to address it. In many ways, if a judge has said, well, it says you can access it, you can't make copies, you can't do anything, you have to do it there. I can't think of any appeals from that, where it's been something that's gone on that people have made it work. Page 34, section 2 on deferred sentences. You go from it goes from expungement to sealing. Obviously, a policy. My only concern is that it doesn't clearly say for conviction or for deferred agreements entered in imposed on or before June 30 of 2025, the defendant shall be entitled to expungement and not sealing.
Right. Got it.
Yeah, so something like that, because even though courts would address it under ex post facto, we have the potential for potentially some prosecutors could argue that, well, it's different. So,
Yeah. Okay.
with that, those are the only comments I have on the new changes.
Okay. Any other questions for Judge Doty?
Yes, one. I think you were saying that the court has an obligation to send a notice of sealing to entities that they know might have records. Is that something that, as far as the process goes moving forward, if S12 goes forward, that when a petitioner came in and was before the court, that the judge could have like a series of questions to basically inform the court about entities that might have record.
Could that happen? Yes. Can I mention that to the judges about looking at that as an aspect? Yes, I can, and I will.
Okay.
I think it's a very good point. But the vast majority of the cases we have are not individuals in court
Yeah.
for the sealing. The
Yeah.
vast majority are papers and it's filings. So
Yeah.
we're not going to have that interaction. That
Yeah.
will be the 1 in 100, probably not even 1 in 100.
Yeah. Okay. Thank you.
All right. Thank you very much, Judge.
Thank you. Have a great day.
So we go to Attorney Delos next.
Probably like Briscoe.
Oh, well, all right. Well, we can have Chris go first. So Chris is closer to the table.
He
to the
is,
chair,
that's the main
except
concern.
Judge Zoney's blocking him. So
I don't know.
I don't want to throw the judge up.
I've been thrown out.
No, that's okay, Judge. I don't know you well enough. Good afternoon. For the record, Chris Delia, President of Vermont Bankers Association. The last time I was in here, I think my testimony was all of about 30 seconds. Today, unfortunately, it'll be a little bit longer. And Todd, thank you for allowing me to go first. So I want to start by saying that we do not oppose the sealing of criminal records. We understand the public policy discussions and decisions that you're making. We support the notion of the best opportunity out there is to get somebody back into an employment so that they can be productive in society. What I want to share with you is the perspective of the end user, if you will, the one who looks at criminal records. And I'd ask you to think about the different types of industries that are out there. We're not your typical industry when you look at this bill and some of the felonies that are created in this bill. And that's the challenge that we're having with this. As we go through the hiring process with somebody, given the nature of our business, when you interact with a bank, you expect that you're going to get great service, that you're dealing with trustworthy individuals, that there's a solid reputation for the institution that you're working with. My money's safe, my transaction is going to go as I would expect them to. And when we are going through the hiring process and we talk to prospective applicants, the question can come up, do you have any criminal background? We would pull a criminal background check because you have to keep in mind that individuals working with a bank have access to cash, have access to account information, have access to your personal data, wire transfers, et cetera. So when we do that criminal background check, it is designed to understand the depth and breadth of the individual that's sitting before us. It does not automatically disqualify them, but it does give the institution the knowledge that they need to have a conversation, to understand that when I was 18, I did something that was really stupid, but that was many years ago, and we moved past that. What's of concern for our folks in this bill is when you get to page 6 and you look at the designated felony, and I'm sorry, I was working off of as passed, but I think it's the same page in your draft that you just were discussing. I look at starting on line 12, A, forgery and counterfeiting, B, uttering or forged or counterfeit instrument, C, counterfeit paper money, D, possession, use of a credit card skimming device, E, false personation, H, identity theft, J, embezzlement, K, embezzlement by officers of servants of an incorporated bank, M, receiving stolen property, and then X, computer crimes. That's, in our opinion, areas that start to creep into the world that we operate in. We're financial institutions. And if somebody's got a history of identity theft, and we have all kinds of information on our customers, is that the individual we want working with our institution? And if the criminal record is sealed, we won't know that, and we won't be able to make an informed decision. So that's the concern that we have with a process that I think you're trying to create and standardize for the individuals involved. But as an end user of industry that looks at criminal records, that standardization creates a big challenge for us. And again, it's not an automatic disqualifier, but it is important to have those conversations about what happened. So in thinking about this, I came up with 3 thoughts, and I shared this with the chairman. And I will take one off the table right now, but I will at least share it with you that asking for an exemption or an exception in here only opens up Pandora's box for you, and the line will be out the door for everybody else who would like it. So I'm going to take that off the table. However, we would like you to think about one of two things. One, either to eliminate these financial related crimes that are in there, or two, extend the time frame for sealing beyond the 7 years that I think was, at least in my draft, the language was starting on page 17. So that it gives a longer time frame for the institution to know about the record before they go through the hiring process. Beyond that, I've racked my brain and we've talked about it as far as my HR folks in the industry, and that's about the best that we can come up with right now. I understand you may not want to do any of that, but I would at least ask you to consider we are not a typical industry out there. We have concerns about our customers' finances, our customers' data, information, et cetera.
Barbara.
Thank you. I appreciate what you're saying. So I'm wondering, because I feel like I come from a field where also like human services, it very much matters.
Right.
But a lot of states have done expungements already, and I know many of our banks operate in those states. So I'm wondering, how have they been operating in those states where expungement, not even sealing, has gone through? And were there any examples? Because it seemed like these expungement laws were tied to leveling the playing field of like no more risk up than anyone else of committing a crime. So
Yeah, we're not talking about expungement from our perspective
right,
here.
no, I
We're
know,
only talking about sealing of the
Yes.
records.
I understand.
And the largest of my membership, the two largest of my members don't have branches here, so they do operate in other states, but the majority of my small community banks who are here, who don't operate in other states, are the ones who are expressing concern about understanding who is sitting before them and being able to have that conversation. This is trying, from their perspective, trying to minimize as much risk as possible.
And I get that 7 years. From your perspective, you're asking for more years.
Correct.
Like what? What were you thinking? Like how many years?
And
Well, yeah, I guess the question I have on that is what's the difference between 7 and 10 other than 3 years? But I mean, is there, I mean, we've heard testimony related to studies that say that after 7 years, I mean, that's why we picked 7 years, is after that point of time, the population is just as, anybody without a criminal record is just as likely to commit a crime as somebody who had a criminal record but was expunged 7 years later.
Yeah.
That's how that works. So I don't know, what does 10 years get you other than it looks better by 3 years?
well, you have to understand that you're talking with HR folks in the financial institutions. So from their perspective, is there any magic in that number of 10? No, they look at it from the perspective of 3 additional years of having information on the individual can make all the difference to them in the hiring discussions. We could have gone to 12 or 15. We didn't, my talking with them, feel that was reasonable. But some additional time, and I know, Mr. Chairman, I've been in this committee years ago when you were having these conversations about the reports that are out there. And I'm not going to do combative reports that may show different things. I'm merely sharing the perspective of how our folks feel about knowing the information about the prospective employee.
Yeah.
I think, yeah, probably just on that, and maybe you've just answered it, but do you have any evidence that there is like more likely recidivism in these particular types of crimes and on a longer time frame than 7 years than the other crimes that we're looking at?
No, but the concern is I also have no guarantee that somebody isn't going to reoffend. And
True for all of them.
And correct. And when you're talking about having access to people's funds and data, the concern is somebody could reoffend, somebody could find themselves back in a bad situation. And they are now in a stronger position at access to finances and data and wire transfers, et cetera, that make it more tempting to then go ahead and reoffend. So I understand. I, again, was here for part of the discussions with the study years ago.
I wasn't.
There's also, again, no guarantee somebody's not going to reoffend. We feel the risks are challenging.
So remind me, are the, and maybe this, I'll ask an attorney who actually practices. So are these like called crimes of veracity, crimes of honesty, or, I mean, there's this is the category that my understanding is that in a court of law, you can impeach somebody with previous crimes if they go to the individual's veracity. I mean, isn't there, I'm just wondering if there's a way to categorize, if we're going to go with your second idea of a more extended time, is there a way to categorize those kinds of crimes? Because they all have to do with honesty and veracity and the like.
So first of all, I'm not a practicing attorney. So we were looking at this from the perspective of financial crimes. That's how we categorize them. When you're talking about counterfeit, forgery, credit cards, debit cards, skimming devices, et cetera, to us, those were financial related crimes.
Right.
They be categorized differently in the world of practicing attorneys and courts.
Okay. All right. I see. Okay. Yeah. Ken and then Tom.
You have another situation in your business with confidentiality with your employees. They're not to be talking about other people's business and all this other stuff. I think you touched on that a little bit earlier, but there's really no laws against that, is there? I don't have a lawyer in the room.
Laws, I'm not,
Against what?
are you talking?
Banking,
Yes.
confidentiality,
Yep.
right? That is a big rule, a big no-no. You can't talk about that and you can't share that information with
I see what you're asking.
another a customer or something like that, what they know.
Correct. So under our state and federal regulations pertaining to privacy,
Yeah.
we cannot disclose our customers' information. We can't share it. We can't sell it. So for example, if you had an account with us, we could not share that account information or anything about you with even your wife if she were not a signatory on the account. So we are obligated under state and federal law to protect our customers' information, if that's what you're asking.
That's what I'm asking. What happens if an employee does share that information with somebody, like another customer?
Yeah.
What happens?
Well, that's a violation of our privacy policy. The bank would have in place policies to deal with that employee. It would also be subject to review by our examiners. And depending on the nature of the violation, there could be a write-up by the examiner. There could be a fine. There could be a penalty on the institution, depending on, again, the nature of the violation.
So that's, if I'm hearing this correctly, basically that's already covered under current law. And then the financial institutions will basically handle it in.
But you're talking about a violation of privacy regulations, not a violation, not a criminal act of forgery, of embezzlement, of credit card or skimming devices.
No, I'm just talking about my business.
Yep.
Talking to one of their friends about, oh, this or that or something like that. That is a violation.
Can't do that.
That's not a law, is it? That's just,
It's a federal regulation
oh, it
that
is.
was created by Congress. It's also a rule that was created by our Department of Financial Regulation.
Okay, thank you.
Good.
This is clearly a part of your risk management strategy.
Correct.
Wouldn't hire a police officer with a criminal record?
Would we? We'd want to know about the criminal record and then have the conversation. We do hire many police officers
No,
as our,
I'm just, yeah,
as our security officers. actually.
right. Now, the only other way, I've been trying to figure out a way around this, and the only thing I could come up with doesn't really sound appropriate, but do any other banks, do banks poly people,
Banks,
polygraph employees?
not that I know of.
And that's expensive and probably,
Yeah, I've never come across that in any conversations that I've had in 22
but
years.
that would be the only way I could figure out. I mean, you're not asking about a criminal record, you're just asking about past behavior. That would really be the only way to.
I would think, but I'm not sure we want to go down that road.
Right.
Yeah.
Other questions for Chris? Not seeing any, so we will have a discussion about what to do
Yep.
about that,
Appreciate your time.
question, get other, get other folks to weigh in on that as well. Well, thank you.
Thank you.
Mr. Chair,
Yes.
that conversation that he was referring to when we did that work, you remember, Tim, ban the box. That was very similar to the testimony that they had offered back then.
We have Morgan Stanley or something in testify.
Yeah.
That was a long time ago.
Some things,
Never last by any.
some things creep out of it.
I know, every once in a while.
Was.
All
Yeah.
right, and Todd, if you could join us as well.
Good afternoon. For the record, Todd Delos, Assistant Attorney General. How's everybody doing? It's good that you said that. Richardson, right.
Yeah, why do you ask?
It's a really, can we reset? I don't have a lot to add to the latest draft. Appreciated the conversation around it. I think the only testimony we had last week on this has been incorporated under 7607, looking at page 25. We had just requested the ability to access criminal and use criminal records in response to potential litigation against the state. We think that the language added lines 13 to 16 appropriately respond to that. So we appreciate that opportunity. We also suggested one other change, unless there are questions on 7607C1, page 25, lines 13 to 16. The other change we requested was page 27. It's the same section, it's another exemption. It's right at the top, lines 1 to 4. So this, what we'd asked to be added here is that all discovery obligations are mutual. So what the original language said is that the state's attorney shall disclose information contained in sealed criminal history records when required to meet discovery obligations. We wanted to make sure, again, in the civil, not the criminal context, in the event that the state doesn't have the same records because they've been expunged or sealed or otherwise destroyed, that we are not, that sealing doesn't provide some kind of control in a discovery dispute where the records are relevant to the issues in litigation. And again, in this instance, at least from where I sit, it is the state is defending itself against a plaintiff and a claim by the plaintiff. And what has happened in the past is we've ended up in discovery disputes where the court is making a call of whether a sealed record could or could not be disclosed as part of the dispute, where the state was seeking the records, and ultimately the court worked it out as some, not all, and from our perspective, we would have preferred more information, but the goal is really just to clarify that. And again, discovery obligations, my read on it is that still falls to the court to determine where those obligations actually lie.
So on that one, if we were to use your language, does that mean that every time the AG does offices in litigation, civil litigation, that the first question on their discovery is going to be to provide every single criminal record by your plaintiff and every witness plan to use at court?
No.
Could it?
I don't believe so.
Because that would
if it's not relevant. I mean, there could be more. I would get back to what discovery obligations, one, I would say as a former practitioner in the civil division of the AG's office, we didn't go on fishing expeditions to just figure out what was going on. We wanted to keep things focused on the matter at hand and the issues raised in the complaint. But beyond that, I would say that's the court. The court would be the gatekeeper there if necessary. But I also think good civil practice would suggest you don't just go casting it out.
Other questions for Tom? You don't get to go yet. I have questions. Karen.
Yes, two. So with this, so I just want to, so you support the language as changed.
Yes.
Great. And can I go to a different part?
Wait.
Well, I was just curious because I remember last year it was the Attorney General's office that had insight on some of the specific charges or offenses, being allowed or not. And I know I missed some of our previous witnesses' testimony, but I gathered it was finance-related offenses. So curious if you have thoughts on that, because my piece was about the 7 years, there's data for that. And I think we landed on that last year, but maybe something has changed in the year. And so curious if you have thoughts.
I am unaware of any, thank you for asking. I am unaware of any changes, and I believe that the previous witness did not at hand have evidence suggesting a different basis for what this committee has already determined is an appropriate level of duration for suing for any number of these.
Great, thank you.
Yes.
So any comment on the restrictions that we lifted on page 25 as far as not requiring a petition to access criminal history records that are sealed? That would be on lines 17 to 20. This is the language that we currently have. We've changed it a little bit, but instead of the petition for access. Any view of that change?
I want to make sure I'm following. So on draft 1.2, page 25.
Lines, it's subdivision C2.
Yeah. No, I think I understand the intent there. From where we sit, I think there could be. I think we sit with other criminal justice agencies. And again, as this committee is aware, our main criminal justice investigatory arm is ICAC. And so to the extent that a sealed record could be relevant to an ICAC investigation, it would go through the process of seeking to unseal it via a court process.
The other question is just looking at primarily at the felonies. This is something I just want to float with various witnesses, including Tucker and Kim when they testify. If we're lifting restrictions, which I think we definitely are by getting rid of that petition requirement and opening this up more for criminal justice agencies to use the documents, access and use the documents for criminal justice purposes, and only if they're going to go into court with the documents do they have to notify the court and get permission, essentially. That we may, perhaps folks are more open to expanding the felonies that would be sealable, since we're getting that additional access. or lifting those restrictions. And what I would propose looking at, and if you have any comment on this, is we do have a definition of nonviolent felonies. It's found in 28 BSA section 301. And perhaps that definition may need to be tweaked a little bit, frankly, when I look at it, but it's essentially listed crimes and any offenses involving sexual exploitation of children in chapter 64. Just thinking about a different approach to allowing broader number of felonies if we are lifting restrictions on the other end.
I could certainly see merit in examining adding additional felonies. I think the challenge with looking at 28-301, I'm not sure it sweeps as broadly as the committee actually might be interested in sweeping. And I think the current, I went through at the chair's suggestion and looked at the designated felonies as laid out in the current draft, and then, fairly informally began looking at other felonies that are out there that may not be included, things like commercial fraud that would appear, and I'm sure the Banking Association may feel differently about this, but that would appear to fall into similar categories of existing felonies. That may be a more fruitful exercise, is going chapter by chapter. And I say that in part because it would let, to the extent that there's interest, it would let interested stakeholders directly see what potential, I don't want to sit and suggest to this committee without the benefit of other stakeholders, like, oh, well, if you get rid of bill of lading fraud, which has a potential felony penalty to it, I have no idea what that would mean. But I presume, much like other property-related crimes, 7 years would suggest that recidivism meets the same as anybody else who has not committed a crime. And so there could be a number of other crimes. There's some interesting other statutes out there that penalize vagrancy with a potential felony penalty in it. So I could imagine addition of other statutes, but at least a recommendation to the committee, and it would, of course, be the policy call of the committee, is by going chapter by chapter as opposed to inclusion by inclusion as opposed to inclusion by exclusion, right? If you just say all nonviolent felonies as listed in 28-301, then people have to kind of do verbal math versus saying, look, let's look at chapter 49 of Title 13. Are there elements of the felonies in that would seem to need to be excluded from the bill, as just purely as an example? Am I making sense there? That looking chapter by chapter would at least give the stakeholders the opportunity to say, here's why these crimes are different. And I think it gets back to Representative Dolan's question, which is, are they?
This is a new change that we're taking on.
Well, I'm just, no, there's no change in the offing right now. I'm proposing that as a possibility if we're going to run into headwinds on having lifted restrictions.
Are we running into headwinds on?
I don't know. Just thinking ahead. Yeah, I mean, since I have the witnesses here, we have asked, including Marshall, to tell us what additional felonies they might be willing to put in there. And
I think that's good.
Continue to, yeah, all of them. Marshall.
Other gambling is another one that you could look at.
Here's one: failure to pay tax or file tax return. Did you know that that's a 3-year felony? That would seem to be
Not common.
false or fraudulent return. We don't want that, but
I think you want to get every penny when you can, right?
well,
How many
So there's a tobacco tax stamp, forgery of a tobacco tax stamp. I don't think we have that included yet. That's up to 5 years.
Yeah.
And it's a minimum. There's a minimum 1 year on that one.
That's federal. Usually a very
What's
big
that?
crime.
That's federal, right?
No, these are all state crimes.
Years.
That usually involves a tractor trailer load of cigarettes typically when we're talking about.
So what's the
Sure.
total number of felonies that you're potentially adding?
I have no idea. I mean, I was suggesting one approach to look at it, and there's a definition of nonviolent felonies. And I think that concept sounds okay. If it's nonviolent, non-sexual felonies, what are those? And I'm just giving you some examples of other ones that are are out there. So
So what's in statute now that we do seal or expunge? What's in the bill, is that adding to the total number?
yes. Yeah, the property crimes, and some of the, sales, not just possession. Current laws doesn't have those property crimes, if I'm remembering right, and does have just possession crimes,
Right.
not like the low level.
And judges in here, but how much work is that gonna add to the judiciary? As far as sealing goes, I know it's gonna have work,
That's gonna essentially be,
and then if we go add more,
Right, yeah, no, yeah, I'm not tied to this all, I'm just
Right,
kind of
right.
throwing it out there for, since we.
no, my mind isn't totally closed to it, but we're expanding it now, the number of crimes. And would it make sense to, as time goes on, as years go on, just look at a little piece to potentially add to it going down the road, instead of trying to throw everything into the bucket at once and
So that,
potentially putting some felonies in there that we may not intend to and overwhelming the judiciary.
really make the point, yeah. On the other hand, though, there's, this would be, as far as on one side of this whole issue, we have many entities that want to have access to sealed documents, including the stuff that we already allow to be expunged. And there's a lot of people that don't want to do that. The trade-off is expanding the offenses that people can say they don't
So
have a
you're-
criminal record. So
So you're
that's,
teasing people in here.
no, I mean, I think not just here, I think
Okay.
it's been witnesses, it's certainly been the Senate, which I don't, recall that. They couldn't even get the bill out last year, so I'm just thinking ahead, it's like, all right, well, is there a way to sweeten this kind of, because we're going, or at least this draft takes away these restrictions that the Senate rejected last year, although we had the 10-year so-called superseding. We've taken away, or at least this draft has taken away the petition to the court because it doesn't work in my view, or not my view, but
Right.
from what I've kind of heard from witnesses.
Right. It just
So-
crossed my mind, if we go too far and add too much,
Right,
we're gonna go from a, probably, right now, I'm gonna assume it's pretty solid vote as far as the committee goes,
right.
and you could go into a very weak vote. And go from a bipartisan bill to a very, very partisan bill. It's just the reality of it.
Right, yeah, no, I understand it. I'm just trying to see if there are felonies that are not the sexual felonies or violent felonies that could be included.
there's some very, very damaging nonviolent felonies.
Yeah, I mean, well, I would say most of the felonies that we're talking about here are damaging. There's no doubt that the property crimes are damaging felonies. But the idea is that after 7 years of, it's an incentive to behave for 7 years after serving one sentence so that they can say that they don't have a criminal record.
Yeah, DUIs do 80 to 100 times in between each catch, so without getting caught.
But there's that too.
So
Yep, that lots of.
I don't think we're making anything safer by doing what we're doing here, thinking about it.
Right. Understood. Anyway, we've gone into a little bit of discussion there, but that's it.
Wow,
But no, I started it. I started it.
So-
Yeah, no,
I
I
have a
started
question for you, actually.
it. I started it. It started with the question, but I started it. Absolutely. I mean, I'm giving you the rationale for why I've asked that question and why I'm asking as far as to understand why we might want to add felonies to this at this point. So anyway, did you have an answer anyway?
I think my main answer was, to the extent the committee wants to add felonies, I would recommend going chapter by chapter within Title
Right.
14 as opposed to including a whole
Understood.
slew and then excluding from that inclusion.
Right, understood. Okay, all right. Anything else for Todd? I don't see anything else.
How are you doing today?
All right, Kim. So I apologize. I did want to ask Todd one other question, but you stay there. That's fine. So any reaction to the testimony of Chris Delia?
I think other than the response to.
Oh, that's right. Okay, that's right. Sorry. God, apparently I'm not doing it.
You're not gonna let him finish?
No. Now I remember. My memory has been refreshed. Asked and answered.
Yes, that would be.
You want me to get your coffee?
Yeah. Yeah, thank you for being here.
Hello, everyone.
I just call on people from now on.
Okay. For the record, Kim McManus, Department of State's Attorneys and Sheriffs. Thank you for having us back in on S12. We have a few comments and then we'll happily address the question that was just posed. I'll wait till the end though on that if that's okay. So going right to page 25, the area that we've expressed interest and concern with as far as we appreciated this committee's understanding of law enforcement using sealed records and kind of the operational piece that would get confusing, whether we change the word access use, whatnot. So we fully appreciate that you considered that and that you removed that language. My understanding from when we were last here was that the committee's goal was to remove that requirement from law enforcement, but require prosecutors to seek permission before using sealed records in court, either in open court or filing. And my understanding of how this went about in this draft, I appreciate the approach for what I think was sort of streamlined simplicity. I'm afraid that it's actually going to cause our prosecutors a bit more confusion. And so we have a suggestion on this. But essentially, by taking us out of the exceptions, so that we're on page 25, subsection C, line 4, we were previously one of the numbered exceptions that this did not apply to, that we didn't need to seek permission from the court. In our current law, we fall under the ability to use criminal justice records if it's for a criminal justice purpose. And so we would bring it up when we thought it was appropriate to bring it up in court proceedings. Now, understanding that the committee wants to strike this balance, by removing us from the exceptions there and having us fall into this first sentence that we're a party seeking to use the criminal history record, we don't understand what determination the court would be using here for whether we could use these records or not, because we've never used this section before. And frankly, anyone who usually use sealed records wouldn't be using this. This would be civil litigation, which there's a lot of time between filings. There's a lot of time to ask permission. And one of the issues I had raised with this committee was one of the scenarios where we would use sealed records is in a flash site bail argument, where we may not have time to file a petition with the court to use the sealed record in a filing to make a motion to hold without bail within hours of going to arraignment, getting all that information back and forth. Often we need to either put it in the filing and then bring it up in open court. So all to say, we're a little worried that the way this has been worded is going to cause us sort of unintended problems down the road.
Before you go, I want to make sure I understand that, because I guess I thought C in lines 4 through 6 essentially covered that situation you just mentioned, that you have a bail hearing on a flash site, you want to use a sealed record, you notify the court. I mean, it could be Your Honor, I want to use a sealed record, and then you go in camera and deal with it there. So what am I missing on that? I guess
So the open court language does. Or in a public filing, that's where we could get stuck. So like for a hold without bail, we might make that an oral request at the bail hearing, at arraignment. More often than not, we are furiously typing up a motion to hold without bail to get filed before that arraignment. And so if we wanted to put the sealed record in our motion to file, we're first going to have to ask permission to use that in that filing, or we need to leave it out of our filing and then bring it up orally in court.
so that's just,
So
so
that's
it's just the oral and the public filing is the part that,
So the public filing part's the first part. The second part is the sentence. The court shall thereafter determine whether the record may be used prior to its disclosure in the proceeding. We don't know, and I tried to see if there was any case law on what this determination is based on, and I couldn't find anything.
so what basis?
So what basis? And we would like it to be the basis that we're articulating the criminal justice purpose to use that record. So so that's our problem. Our hopeful solution, we think might be easy, is if you look at number 3 has language, and we don't want this language, I'll put that out there, but I use it as an example. Number 3 gave language of the court may grant access upon the finding that the sealed records may be of assistance to the attorney. So the attorney knows what they need to do to make the argument. So what we would ask is that under subsection C2, that there's a sentence added that essentially, and no need to quote me on this, but just to think about that the court will allow a prosecutor to use a sealed criminal history record in open court, provided that we give notice and articulate the criminal justice purpose for it. So we still need to have that step of asking, but we understand what the determination is going to be made.
So that's a question on that. I mean, with that language, I mean, we should need to have Judge Zone in on that again. It would seem to me that the court would be looking at relevance and prejudice. I mean, they do that all the time, don't they?
Well, relevance, but again, whether we think it's tied to criminal justice purpose, and we have a definition that we know. So we would just want to make it clear that is this relevant to criminal justice purpose? Then we can use it.
You're in a bail hearing, you would think.
You would hope, but again, we're just concerned that the language in subsection C, we're just raising the issue. We don't know what they're determining that on. So our preference, our request is that we are added back into the numbers that are accepted here, and then we add a sentence within our exception of how and when we asked to use this, just to make it more clear.
Not only do you want to have it in front of you, because you have to prepare it and then not redact it or anything. That's kind of ridiculous, or have 2 different files. You can't send it to the judge straight away, so he can have it she can have it prior to the hearing. Before they go in, they like to read these things and know what they're talking about before they go in.
Ideally, right, why we want to file that motion. So to your point, we wouldn't want to have 2 motions drafted, one with the sealed information, one without, and then wait for that request. So essentially, we'd like to ask you to consider noodling around a little bit more, just a little bit. We're so close, and we accept this idea. We want to make that very clear that we suggested this on the Senate side. We don't mind having this check. We just want to make sure that we didn't accidentally cause a problem for ourselves by asking for it.
What would be the circumstances you would want to use that record?
So the example we've given a few times is the flash site fail piece, and that's the one where we don't have a lot of time. Other instances, like a sentencing argument, there's more time for the back and forth. So this was the one, again, when we talked about, we had the exigent language. We're like, oh, we don't need the exigent language anymore if we really move the petition, except I said, oh, except prosecutors sometimes have an exigent.
Would it be a re-offense situation until you're trying to bring to light?
Right. So the scenario would be, aggravated domestic that's in front of us. We're asking for a hold, saying that, there's substantial evidence that there'll be future violence. And then if the sealed record, there are a number of simple assaults that have been reduced from domestic violence, domestic assault charges, same victim, maybe same pattern, there'd be reasons why we would want to use those in that moment. And again, this doesn't come up often, but when it does, it's needed, and we wouldn't want to trip ourselves up accidentally.
But wouldn't that be you're there in court and you say, Your Honor, may I approach the bench for a bench conference? You go up there and say, I have the sealed record. It's got these things. I'm notifying you. Please take a look, whatever. He takes a look at it and decides relevance, prejudice, or he has an argument in camera and you figure it out right then. So I guess on that part, I'm not seeing it.
So handed the criminal record 20 minutes before court, and I'm like, ooh, look at this. Yes, then, Your Honor, we need to approach. I'm notifying you, I'm asking. That open court part, I think, covers that scenario. When we're doing a motion to hold, 7553A, violent felony, substantial risk, we generally don't do that orally. I mean, we can if we have to, but we quickly write a 5-6 page motion arguing why this person should be held. And that's if we need to, before filing that motion, get permission
Would
for
you
that
just
sealed
file,
record.
you'd file attached to that motion or as a separate motion, an addendum, I don't know exactly, it's been a while since I looked at this Odyssey thing, that under seal, that you also, at the same time, you're filing that sealed document under seal saying, I'm notifying, we'd like to also use this. So
If that's what we would want to be clear on, like if that, so
it's under seal and the court's not going to use it until they've been notified and they make whatever that finding is that we have to look at. I guess I'm just not seeing how, maybe I'm saying, Ian, you're in court.
I just want to know, how much of your 5 to 6 page motion on the bail on a whole motion is going to be based on a 7-year-old sealed record, even older from when the actual incident occurred, right? Like, it's probably not the majority of the argument.
No.
And so
Yeah.
why can't, in the same envelope, I'll use some Odyssey language, in the same envelope, so you can file, I think you can do this in the same envelope, you can file the general motion, and then you can file this other one under seal or, a non-public with the attached sealed record, right?
But we can't make the argument in the public filing about the sealed record. Like, I can't reference it.
Until the court
Until
looks at it and they say it's fine.
Yes.
Right. And if they say it's not fine, then
Better have had a
I haven't.
record argument, public argument.
We have concerns as expressed that we think this could be just neater and cleaner. And so if it's possible for us to have that be cleaner, we would like it.
So I guess let me ask how we would clean it up. Is that dropping back into subdivision C2, the petition for use of the document, or no?
Well, I think exactly, just from a visual, sorry, this is the way my brain operates. Putting us back, accepting us from here, putting 2 back in here.
Right.
And then within our subsection 2, adding a sentence using the language that was similar to the petition, that basically in there, we were asking for use based on reasonable suspicion that this may serve a criminal justice purpose. I think we can play around with that language, but just a sentence here of needs to notify the court prior to use in open court. And then attaching the determination to criminal justice purpose. Because again, if you look at number 3 for defense attorneys not part of the defender general, there's a sentence or 2 of there directing them how to go about doing this.
That's just access. That's not to get used.
It's not use. Okay.
So I really was hoping to try to have all that use language up in subsection C, and I don't know why we have to drop it into C2 as well. Because I also don't want to confuse, I mean, I understand where state's court, where the state's attorneys are coming from, but I'm trying to avoid law enforcement doing investigations, feeling that somehow they have to petition for access or use.
Well, and it would be worded, if we went into subsection C2, the sentence would start something to the effect of, the court may allow a prosecutor, or a prosecutor shall request, we would specifically use the word prosecutor in that sentence, not criminal justice agency. So again, this is you put this burden, for lack of another word, on prosecutors before using these records. And currently we do not have this restriction. We can bring it up if it's a criminal justice purpose. So we just want to be clear on how we're doing it and how the court's determining that we can do it.
So how does the prosecutor use the sealed documents now? If they,
again, it would,
scenarios that you're talking about?
They would write it in the motion to hold without bail. There'd be reference to prior conviction for that had been produced from.
And had been sealed.
Mm-hmm.
Yeah.
So maybe the way it would go would be that you would file the motion. I'm trying to think of, I'm agreeing with you, trying to noodle it to understand how it actually would happen in practice. Would it be that if we went with language here, an SA would file the motion and the attached sealed record all in a non-public filing, and they would make the argument in that motion to use it. And if the court denied it, then they would have to refile, excluding it. That would, I'm right. I think that's probably, if I think, yeah.
In the morning of a flashlight site, I can tell you
So why,
the deputy
and
state's
you can't,
attorney is going to be.
you couldn't make the motion and then you couldn't file the motion and then make the argument sealed record in open court when you're arguing the motion.
I think you can file the motion, but again, currently would not be able to reference that past criminal history.
Yeah.
And often, we run through, it's not a huge part to your earlier question, but depending on a person's criminal history, it can be a fair amount of that.
Yeah.
And going into why that ties to why we believe this is, evidence of potential future violence in that scenario.
Huh.
So we're just worried about getting hung up there.
This bill.
But we're so close. And
I guess I'm still not quite understanding why, maybe I'm being thick and not understanding why subsection C, other than that second sentence, doesn't cover that. And we're trying to keep it pretty unfettered in subdivision C2. But once you're going to use this in court and public, that's where we're putting the restriction, and that's for anybody using it in court. And that's except for 147 apparently. Right.
Will it actually interrupt our goal of keeping people from not being able to get a job or an apartment? I mean, you're using it in a hearing as evidence. And if it goes somewhere, it does. If it doesn't go anywhere, as far as your motion, who's where will it be seen? We just continue to seal that. Follow the trailer. So
So, right, so any filing that's a request to the court, when the court acts on that, that becomes a public record that can be requested and is accessible. So again, we don't want to violate.
but you're using it for a
Yes, either.
criminal justice purpose. I mean,
Yes.
it would be theoretical if they were convicted, it would be outed. Or not acquitted, or convicted, it would be a whole new game again. Right?
I don't know what we mean by whole new game.
Well,
but-
people would see that it had existed. Because it was a second conviction or something, if you're doing a.
If it was something,
Yeah.
yeah, something like that with a predicate
And that's
offense.
why we're making them available, so predicate offenses could be charged. That wasn't our decision.
Yep, there were a number of the things that would fall under predicate offense would not be sealed as convictions. So our concern are more offenses that start off as a non-qualifying offense and then are reduced and then sealed. But the underlying behavior was something that would not have been sealed in the first place.
But if there was no conviction, you could barely. Well, no conviction, it's gone anyway, right? The record.
If there's an acquittal, it would be sealed. Or no probable cause found, it would be sealed under this.
And then there's no jeopardy.
It'd be closed up as well. So it would just be any of the public records. It would be sealed after, to your point, yes. So we raised that concern.
Oh, boy. So I guess just one last thing on that, and then we'll have to noodle some more.
Yeah.
If we put,
No more
if
noodles.
we put in C2, I mean, additional language slightly different for getting these documents in court or public filing. Doesn't that confuse things when we already have language in C that's talking about the use of these documents in court? I mean, what is C even for?
Well, that we don't know because we've never used it because we've always been accepted. So that's our problem is that I think this exception is for all the other folks. And again, I guess this is on the civil side, but we've never used this section.
Right, okay.
It's not, we don't know what standard is being used there. And again, we would hope we could tie it to criminal justice purpose, but if that's not clear,
Right.
we may have different decisions in different counties. That's what
Do you have proposed language?
I do have some proposed language that I can send in, absolutely.
Right, all right.
We know how well I am at drafting legislation, so.
This is tough.
I think I'm 0 for 2 right now. Maybe this is my moment to shine. Moving on, if that's okay. I think we commented already last week on the deferred records. If that's a choice of the committee, for all the reasons why we support sealing records, we support that. But we also want to be clear, we don't want that to be a deal breaker of the bill moving forward. So we do support it, but it was not our request.
Sorry.
Yeah, don't put that on us. But again, we do support it, just to be clear, on this warm afternoon. So the question about felonies, our department would ask to greatly pause on that idea. We do appreciate that things have been removed from the Senate version. I would hope that there's room in between there, especially given the amount of time you all took to consider the removal of the petition, to be able to argue to the Senate successfully, like why that was done. And then we don't necessarily need to like trade some felonies to go in there. So that's just one comment. The use of the 28 VSA 301, I have a list and I printed it out for you all, and I don't necessarily need to share it, and it's not exhaustive by any means, but if you remove the sexual exploitation of children charges, which would be part of that non-violent felony, we still have a big list of felonies that we would not want sealed. Just to mention a few, domestic terrorism, Chapter 37, which is all about explosives, using explosives, making explosives, selling explosives, being harmed by explosives, an assortment of arson offenses that are not in the Big 14, including burning forests, law enforcement use of chokeholds causing death or serious injury is in there, aggravated stalking, a number of offenses involving bribery, including bribing public officials and public officials taking bribes.
See that?
Yeah, that would be a separate conversation. All the escapes, unlawful aiding of an escape of a DOS, Department of Corrections employee or law enforcement officer. A number of embezzlement charges that are not currently here. There is, to Todd's point earlier, I would not want to use that nonviolent felony offense. It's a bit misleading in that there are plenty of violent felonies that are not accounted for in the Big 14 or the listed crimes. And so you would want to go through, if there were some suggestions, as I heard mentioned earlier, of some felonies that you would like us to consider, we'd be happy to consider, if you have a list of felonies to look at, but we would definitely object to saying everything but, Big 14 or listed offenses. There's just too many serious felonies that should not be sealed.
So should we not this year update that definition of nonviolent felonies? So that
And I think, I think that's been a discussion, not to say the word data and get us all back there, but, this idea of violent felony and nonviolent felony, we do not have great definitions for that or definitions that are being used regularly. So that would be something. I don't know if that's something you want to take on at this point in time.
well, not this week.
Next week, maybe, right,
Not
sure.
this month either. But I mean, we also are long overdue for looking at the list of crimes as well. And there was a great proposal 7 years ago from Judge Keeble, then state's attorney, that somehow didn't advance. But putting that aside, okay.
And to that point, if the conversation is restructuring the big offenses or the listed crimes, then that would be greatly change, right, that assessment.
So one more question I have, and it's kind of bigger. I don't know if it's a philosophical question, but it's like, so why shouldn't we seal even violent crimes if we're giving essentially full access to those records for somebody who for 7 years has not done anything, that they should have the opportunity to have their record sealed so they can go on with their life? I mean, why, especially since you can object, the state's attorney can even object in the interest of justice that shouldn't be sealed. So why shouldn't we have essentially all crimes sealable?
Wow. All crimes? No, we're just throwing it up wide of.
Or maybe the lower level, I mean, so yeah, what's the?
We'll start with all. Let's start with all.
Oh, that's easy.
So
Not, I'll probably go nuts.
I think you'll like my answer. So Ken, while there is information about, the term aging out of criminal behavior is used often. there are some crimes that people do not age out of. Sexual exploitation of children, sexual predators do not age out of their offenses, and there is plenty of literature to support that. And there are other crimes, and it was interesting to hear, and I'll go look for it, but I believe embezzlement is also a crime that people do not age out of when they tend to get into that behavior when the opportunity presents later on. There have been a number of known cases that, the person working at the company who's been writing checks, not surprisingly, years later, does it at another company. So you would really want to break down all the criminal offenses and look at that data of who, certain crimes, folks, high likelihood of aging out of. Other crimes, not so much. And there's data to support that. So let's take away all and then look at just some of the nonviolent felonies that I just mentioned, which could have potentially, which are pretty violent. I think then you would want, from a larger public safety view, look at the employers for people who work with children, people who work with vulnerable adults. And again, while there may be less of a likelihood, would you really want someone who has a past conviction of working with explosives to get a job working at a school, or getting a job working in the Capitol building with a domestic terrorism conviction, even if it's 15 years later? The what if, from a risk management point of view, I don't know if employers would want to take that on. And I think that's an incredible risk to ask of. So I think, again, maybe there's a space there. Again, it makes me nervous too with housing, certain crimes. I don't know, I'd be very reticent. I think right now, the bill before us strikes a really good balance. I think you've added a number of felonies in here that, as you said, do cause damage, but they're monetary damage. More, I don't even want to say more likely not to reoffend. I don't know if that's really fair to say, but I think right now you have a balance, and I don't think now's the time to add in more felonies. I think.
I appreciate that. Let me just ask before I go to Ken and follow up on that. One thing you didn't mention is for some of these crimes, the perspective of the victim and how they would feel if all of a sudden the person's able to say that they don't have a criminal record, they didn't commit the sexual assault, they didn't commit the aggravated assault, the murder, etc. I think that's another important factor.
Absolutely, and I'm so glad you said that. Yeah, especially when we're talking big picture, all
Right.
felonies.
I'm not saying I want to do that. I just wanted to have that conversation, understand that a little bit better. Ken, go ahead.
I'd just like to understand what age out means for judiciary terms.
So that
So then I could have followed this conversation a lot earlier.
Sorry, I apologize.
It's not your fault.
There's there are a number of charts that will show, and I don't have the age in mind, but essentially the criminal behavior sort of peaks as far as, in the 20s or 30s. And then even someone who's committed certain crimes in their 20s and 30s, as they age, as they get into their 40s and 50s, less likely, with every year, sort of less likely to reoffend. So someone who was, 25 and committed a robbery, less likely that when they're 45, that they would be doing the same type of behavior. That's when they refer to age. So not aging out as far as jurisdictional, we've used that, but not in those terms, but just as we age, we generally, for most crimes, have less proclivity to sort of do crime. But again, there are exceptions to that.
So it's a sliding scale. The person that has done something that you decide whether they age out or not. It could be somebody that did something in their 50s, and then all of a sudden at 65 or 66 did something again, And you'd be determining at that time whether they age out or not?
No, I apologize. I didn't explain that well. So
Well, maybe I'm just not that smart.
that's not true. I can explain it better. The term is used when looking back at someone's criminal history.
Yeah.
You might see when they're younger, more likely to have criminal interactions.
Right.
And that same person, so say, when I was 19, I broke into a store and stole some clothes. Kim at 19, maybe did that behavior. Me at 29, probably less likely, but maybe I have sticky fingers, maybe I like stealing things. But as I get older, the odds of me doing that lower. So it's just that so when folks talk about recidivism rates and, this whole idea of ceiling is that after 7 years, it's less likely that someone will commit a crime.
Yeah.
Not a guarantee, just less likely.
Okay. Thank you.
I can't help myself but to ask this one. So I saw a study, or I saw something recently that suggested there's actually a bigger increase in crime by the older like 40s and 50s, that they're seeing a larger increase in criminal behavior than in the younger. I mean, just as far as a trend, so you haven't seen anything like that with respect to Vermont. This is like
it's interesting. I was looking at Department of Corrections incarceration database that you can interact with and play around with. And I was interested to see that our largest incarcerated population is older. So that does, I don't know how that, I don't know the details deep enough, but it was interesting. So I don't know what the trends are. What's generally mentioned is this idea that we have less criminal activity, but when I looked at the incarceration rate, it was interesting to see that our largest percentage, when we look at age, are folks in their 40s and 50s. So we may be.
And we don't hold people for long periods of time either. So there's probably folks that might have been incarcerated.
Yeah.
Anyway,
And so interesting.
Yeah.
So right. So that whole, I'm not going to argue the merits of it, but that's what the argument is.
All right. Well, thank you. We'll look at that language and further noodle.
And again, and I just want to emphasize, we as a department are so grateful to be this close, and we feel like we are this close, and we do want this to move forward. So we're not trying to work against where we are, is our point. We do just, if we're making this change, and again, it's a change that we suggested to move this bill forward, we just want to clarify the language so that our prosecutors, when they need it, can actually use the records as we sort of all intended.
Good. Thank you.
Thank you.
All right, Tucker, you have the last word, at least for this particular day. Well, I didn't ask you about diversion, but I can do that some other time after we have
Sure.
Willa and Tucker, over to you. Please identify yourself for the record and proceed. And you can address anything or nothing that we've talked about.
Yeah, good afternoon, Chair Lalonde. Good afternoon, everyone. I'll be pretty quick today. I wanted to let everyone know that I did post my notes that I was referencing 2 weeks ago during my testimony. So that's online now. You have that. It includes the data I was referencing on deferreds. And that was the data from CRG. And then I also included the information I had there from the diversion records that I was citing about the DUI, number of DUIs per year sent to diversion. And that's also a reference to CRG's Act 40 reporting. So, just so you have that handy, that's available for you. It was really just that, and then this other topic, which really Kim and Todd covered, on this idea that you floated, Chair Lalonde, of kind of expanding to all felonies except. And, whatever way you cut it, the problem that we run into is that the list of listed offenses is by no means exhaustive. So whether you're using the Title 28 provision, which cross-references the listed offenses, or just the listed offenses themselves, there's so many other felonies out there that I think in short order, the committee would likely decline to extend a ceiling option for that. I don't think that approach makes sense. And, Kim mentioned some of them, but we're talking the gamut really, from weapons of mass destruction to treason to sexual exploitation of a person in the custody of a law enforcement officer, sexual exploitation of minors in certain contexts, which are felonies, sexual exploitation of inmates, I think obstruction of justice, perjury, domestic terrorism, which Kim mentioned, some others. So it's a problematic approach to rely on the listed offenses as your kind of your nonviolent felonies, and wouldn't recommend taking that approach this year or probably ever. That's most of it right there. I have seen the new draft. Thank you for the changes there. In my notes there, you have the additional data on deferreds. I also have it on diversion. I know you're going to kind of talk about that in more detail probably tomorrow. So I really have nothing else to add other than if you have any questions.
Any questions for Tucker at this point? I'm not going to get all philosophical, so I ask those questions. So no, don't answer those philosophical questions.
I won't answer the philosophical questions, Chair Lalonde, other than mentioning it was really under H655 that you went in deep with some of the regulatory entities for professional regulation, and you saw the types of professions that they were regulating. And I think it was during that testimony last year that it hit home for some committee members, the tension between allowing the, sealing and shielding of the criminal history record for those professions that are regulated, and the sensitivity of their work. And so that really we haven't touched on in great detail this session because that has already been hashed out in some detail. But when you ask about these other felonies, it really comes down to these regulated professions and the positions of trust. I mean, banking just today, but we have some professions that are in even more sensitive positions of trust with vulnerable people and children that I think alone cause some understanding of the tension at play with expanding it to these other crimes.
I appreciate that, and I hope it's understood. I'm just exploring the boundaries of this bill to see where there could be give down the road if necessary. So I appreciate that. Any other questions for Tucker? All right, not seeing any. We have tomorrow morning at 9. We are going to have some more witnesses, including trying to track down somebody from DCF on H98, H87. No, H98. Sorry. Yeah.
I got to look. Oh, no, I had something. Yeah.
We had something for Tucker and I missed it?
No. You said DCF. I would love to hear from either a retired federal immigration attorney, prosecutor side, state side, or active. We have all kinds of people on the other side. I want to hear someone from the side. And I
if you have,
think we're running a little bit into their territory, just a little bit.
Sure. No, I'm happy if you.
I'm just not sure where I could call around to find some.
I know Aaron used to do the immigration clinic at UVM. I mean, at Vermont Law.
Right, I mean, what we need is like a US attorney. If we
Yeah, I
got
don't want a
US
private
attorney.
attorney or an
Yeah,
advocate or
but
anything like that. I want,
We've tried in the past to get federal folks to testify and have never been successful at that. So,
because I reached out already to one and I got a really interesting response back.
okay, so is there somebody who would?
No, it was like, well, that's kind of our water, was sort of their
Right,
reply. So,
I mean, if, I'm happy to have somebody, if you have, I don't know off the top of my
I'll see
head
what I
who
can
I would,
find out.
who I would bring in, yeah. So, I mean, there's not, if we need to. So I think it should be on notice calendar tomorrow, possibly. I never quite understand when they send bills over, but I think it was third reading yesterday in the Senate. And so it probably will be on our notice calendar, so it will be up for action on Friday. That's what I was trying to get. But if we find somebody who has a different view or can shed some light on that, we can ask, we can put off. We can just ask for delay if necessary, but hopefully we can find somebody for tomorrow or Friday morning.
I mean, I have no idea what he knows about immigration, but Matthew Bernstein is an attorney and the child advocate.
Yeah, no, I don't think, I mean, I think that's not. So Jill coming tomorrow is an expert on immigration law. But if we're looking for a perspective from the feds, that's what I'm kind of understanding. That's not what they would be providing for us, so. Karen, or Angela.
It's on a different topic, so.
I don't know if we're into, I was just gonna say, I don't see how it's a federal issue.
Right.
Let's not make it a federal issue. I'm sorry, I was
Like,
joking.
the
I was
kids-
joking.
I don't see why it's a state issue because it's not a problem right now and it's going on. Everybody's worried. But when I asked about it a little while ago on a text that I could show you, it clearly could be.
It could be an issue.
It could be. They have their own protocols that they follow for this exact situation, and you don't need to be doubling down if one agency is doing something they're supposed to do, and then you got a state agency now just putting their nose into it. We could jeopardize the simplicity of it.
But wouldn't,
And I don't see a need yet either. I don't know we need to legislate something we already have a solution for, but.
But I mean, this is mainly coming from DCF being concerned that they are going to have to take on, take custody of these kids.
Being concerned.
Yeah, so,
And they've been taking people into custody in this state since I moved here. It happens all the time. I don't see that it's a problem.
All right, well,
So I would like to know why. If it's not a problem, maybe they're doing something good.
yeah, no, see if you can find something. I'm happy to have more further testimony. I don't necessarily agree with the concerns, but that doesn't
Okay.
matter. That doesn't, that's not the point.
I'm not asking.
Right. So no, I'm happy to try to vet this more, if we can find the right folks to testify. So, all right, so Cameron.
Or maybe you're gonna say it, or maybe it already happened. I know I was out for a bit, but it looks like H41 is on the notice calendar for
All
tomorrow.
right, so
Straw poll.
the straw poll on whether to concur with the amendment from the Senate. I'll take a motion. It's the dead body.
Oh.
I think everybody was ready to vote for it yesterday, but I wanted to actually receive the bill before we voted on it. So I can take the straw poll now and I can get Alicia. We can be a little less formal. I'll get Alicia and Tom's vote. Well, we can just do it tomorrow because
Let's do it.
let's just do it tomorrow when we're all here. And we may have, we won't be done with 98 probably by tomorrow.
And any word on S109 if it's.
So I'm planning, in fact, we have to do that still today, having an amendment for us to look at on Thursday after the floor, tomorrow after the floor, just to be prepared, because there are various things we've been hearing from people since we've passed it, which I think I already gave folks a heads up about most of those. But we're going to get some witnesses in because there's still we're finding out that there is a disagreement on some language in the study that we moved over from H193. And so we'll take some testimony and hear from them on that. So, but yeah, otherwise we'll be doing S12, more S12 in the morning and then S109 in the afternoon, and haven't figured out what Friday will look like yet.
Early weekend.
Maybe, or if we're ready, I mean, if,
I may not be here Friday, but
okay, all right.
I'll
So
be here.
So I mean, if for some reason any of this stuff is ready to vote, well, play it by ear.